Hi, I'm Brian Hanning, attorney for businesses and creatives, and today I'm back with my final video in my series on trademark law. And my focus today is going to be on taking our trademarks international. So most of my clients are domestic, most of them are looking to grow, and part of that growth is going beyond the borders of the US. And so it's important to know that there's a couple of international treaties that the US has signed on to for intellectual property. Some of these are things like the Berne Convention for copyrights, the Hague Agreement for industrial design and patents, and we have a number of trademarks, and most of them are governed in some way through the World Intellectual Property Organization. It kind of acts as both a hub globally as well as a independent governing body. And we've talked a bit about trademarks as international pieces before. We vaguely mentioned it when we were talking about how to describe goods and services with the reference to the international classes of goods and services. Those are based on the Nice Agreement, which is, as we're talking about, an international treaty, and it requires that all signatories to it use the same basic listing and classification of goods and services. Another main treaty is the Trademark Law Treaty, and we've touched on this one a little bit as well, because it specifically discusses and lays out how applications go. It covers the types of information that can be collected, the types of information that should be collected, and some of the standardization internationally around that. And then finally, there is the Madrid Agreement or Madrid Protocol. We call it both things because the agreement that provides the protocol. And the protocol is the ability to take your domestic registration and use that number to apply for international trademarks in a single application. So there's nothing preventing you from going to, say, Canada and filing solely in Canada through the Canadian system. But if you want to go much broader, you can apply a single application with a single filing fee through the WIPO. And that application results in registration in 109 member states of the agreement. Some of these include the very important next markets, such as Canada, Mexico, the European Union, China, Australia, Brazil, Egypt, Japan, and many, many more. Using this treaty is not without problems, of course. There's benefits and consequences to everything. But in this case, the big thing is you're reliant on your base home registration. So for my clients, that, like I said, is mostly domestic in the United States. That means if there's something that goes wrong with one of the registrations with the United States, then the WIPO registration gets canceled. So for example, if a trademark in the US is abandoned due to non-use, then your international registration is abandoned. Alternatively, that means your international registrations can't be challenged except through US process and procedures. Or if they can, it's a very limited and much more difficult process. These treaties recognize business and ideas don't stop at international borders. And the treaties make addressing such international affairs a little bit more approachable. I do still recommend, especially if you're going to one additional market instead of many additional markets, but even then, to approach local counsel and to see if it makes more sense to go through a particular markets process or through these treaty processes. Because while this treaty does have its advantages, it also is a situation where perhaps there are reasons to go direct to the local trademark office. With all of that in mind, Good luck on getting your trademarks, and I'll see you soon.